All right, we're back. You didn't think I was done this evening, did you? First of all, I have to lend a great amount of gratitude to a man who does the works of the Heavenly Father. He does good works on this earth. He has expedited my retention and learning of this knowledge of equity exponentially. I mean, he's jumped me light years ahead of where I was when I stumbled across his work years and years ago. He's applied a lot of his life to this work that I'm currently reading to you from. He wishes to remain anonymous and will keep it that way. But his works are far too good and too great not to share with the rest of you guys, okay? And everybody's always talking about enforcement. Where do we get enforcement? How are we going to enforce our claims? And I keep telling you guys that, you know, we have John Little out there that's giving great works, along with Carl Lenz, also doing good works. There are just so many people out there doing great things. Even Yusuf L. in the UCC. I just don't dismiss anything anymore. There are remedies on all sides of this, but one of the places that it is second to none is the exclusive jurisdiction equity. And the reason I feel that way is, instead of knowing 66 million statutes, codes, city ordinances, rules and regulations and provisions, I only have to know about 20 maxims and then remain true and pure to the heart and follow and be a lawful man. That's it. It's real simple, and that's why I like equity. You can create your statutory trust, and I'm telling you right now, a statutory trust is not near as tight as an equitable, exclusive jurisdiction equity, pure trust, okay? One that's created with value and consideration, one that makes sure that the trustee can never hire a lawyer, okay? It means everything's going to be done in layman's terms with good conscience for good reason, and it's going to be done and executed on behalf of the beneficiary and the trust. And so, you know, creating your own trust is very important. And once you start to see this, you even learn this about trust in the Weiss Handbook, or the Weiss Handbook, which is a brilliant handbook in its own. But the next part of this, you really have to understand the power of the USPS. And the power of the USPS is just so phenomenal. Remember that it can never be greater than that which from where it came from. So you have General Post and the U.S. Post Office, which still exists, and then you have the USPS. But what's fantastic about the USPS is that you can create your record through there, because remember, the USPO was the original bank and the original court of record. Okay, people hold court through mail. Okay, that's the best way to do it. And so let's get on here. Game plan, enforcement. How are we going to enforce all this knowledge that we're gaining, right? Plaintiff with primary rights, sealed ex parte bill in equity for special and general relief, federal equity practices, and addressed to His Excellency the Chancellor, Clerk, and Master, private chambers of Federal Circuit of the United States Supreme Court of the United States, in care of the U.S. Court of Appeals for Iowa. The proceedings governed by the rules, principles, doctrines, and maxims of equity, cause of action to appoint a trustee to wind up the estate for the heirs, sustake merger of the titles, to extinguish the debts. And I don't know if you guys can hear me better that way or not. I don't know. Here, I'll try and throw this microphone in here and see if this makes it better or worse. Or I don't know if this microphone helps or not, but if it does, great. Give me a thumbs up if you can hear me. Something. All good, he says. All right, we're reading on. All right. This stuff's just too exciting to stop. Now you guys understand why I don't get very much sleep, because it's hard to put this stuff down. I mean, I once had an officer of the law tell me that he this is what he said. He said, Derek, this sovereign citizen shit is worse than a meth addict. He goes, the stuff that you're doing, he goes, this is worse than you being on meth. And I just thought to myself, that is one ignorant ass statement. I ain't never heard something so damn dumb in my life. Are you kidding me? I'm ascending of the mind. I'm trying to better my community. I'm trying to enlighten the people that are around me. I'm trying to protect my family. And you're telling me that you believe that what I'm doing is sovereign citizen shit and that it's worse than being a meth addict? You're fucking nuts. You're worse than fucking nuts. You're knucking futs. So anyway, moving on. The proceedings governed by rules, principles, doctrines, and maxims of equity, cause of action to appoint a trustee to wind up the estate for the heirs, sestake, merge the titles to extinguish the debts, redeposit all res under new trust for your sole benefit, life maintenance and support. No statutes, rules, or codes per substance. Okay, pure substance. And so we're going to go on. Record creation and due process. Private account number. Mail yourself a registered mail number. That will be your label 200. Okay, we're showing you how you're going to build your trust, how you get your numbers. All right. And again, this number, this information was never supposed to be out in the public like it is. But like I said, the man who put this together is a heavenly man. He's a peaceful man. He's been sent here by the Heavenly Father to help us ascend to the mind. I'm going to respect his wishes to the best of my ability, but at the same time, this is a game of numbers. It's like Jim Rohn says, you need numbers in order to find convictions, and we need convicted people. We need people to stand with conviction and knowing that what they're doing is right, just, and honorable and fair. Again, so mailing yourself, it's so simple. You mail yourself a registered number on an envelope. I use one of the big vanilla envelopes, okay? And pay for it using a money order and stamps. Now, this is important. Don't let them Pitney Bow stamp that shit. Because under the Federal Stamp Tax Act of 1863 or 68, we got to pay the taxes on that paper, right? So that $1 stamp is the value and consideration of the creation of the trust, okay? And then, of course, the money order is going to prove that you paid for it in lawful money because the post office allegedly backs their money orders with gold and silver. And, of course, that makes sense to me only because I've studied the post office and I realize there ain't an ounce of gold or a bar of silver or any precious metals that move in this nation without the expressed authorization from the United States Postal Service, period. All right, that's how it works. Use a green card with it a 3811. That's your return receipt. That's going to prove that that the grantee received it. Right. So who's it coming from? It's coming from the all caps name to the man. Okay, and the man's going to sign it as grantee without prejudice. My copies, make copies and store. Record in Lamar County. The reason they say Lamar County, and that's Lamar County, Georgia, is because everything goes through in Lamar County. There ain't any quibbling, there's no fighting, there's no fussing, and all you're doing is getting it registered. It's a notice of deed of acceptance and acknowledgement of the RR number, the registered mail number, which is again on the label 200, and they're going to give you a big fuss when you go to the USPS to ask for these rolls of these label 200s. They're trying to keep you in the military side. They're trying to keep you under military rule. They do not want you executing these processes, okay? But there are ways to go about receiving a couple rolls. First of all, you could tell them that you administer private administrative trusts, okay? And that you do a number of these significant mailings and you need these label 200s to utilize on your documentation before you get to the post office because certain numbers need to be on certain documents, okay? And they will typically go, oh, okay, here you go. If you just go in there and go, I just want these because I want these, they're going to tell you to bug off, okay? They've told me to bug off, and I'm extraordinarily learned about the tactics of going in there and getting these label 200s. I think I've got like 8 rolls laying around at this point, and I just keep them around for emergency purposes. I mean, somebody in my family is going to need a trust soon. I'm going to have to put one together for them. My daughter's going to need one. My pops might need one. My mom might need one. The house might need one. The cars might need one. And so we keep those things on supply, okay? Make copies and store, record in Lamar County, that's Georgia, notice of deed and acceptance of acknowledgement of the RR number, the registered mail number from the label 200 for sufficient valuable consideration, signed signature guarantee or grantee. Okay, you're the grantee of this. Due process, legal notice in newspaper according to local rule. County recorder, registrar, Secretary of State's office for recording notices. Okay, you're just recording a notice. You're not recording your trust. Too many people are out there running around thinking they know something, and they record the whole stinking trust on the record. Well, that defeats the whole idea of a private trust. All you're doing is giving notice of a trust. Remember, earlier we expressed how your private record supersedes their public record. Well, your private record has no weight, force, and effect if you done put it in the frickin' public. So you're only giving them a notice that a trust has been created, okay? And that's going to protect you. You want to protect your assets. Look, when that creepy-ass Rothschild guy died, Mayor Lord Rothschild, do you guys realize that nobody actually knows what the Rothschild's wealth is worth? Because he made it in his will that when he died, that everything that was in a trust never be exposed to the public. You ever wonder why the Rothschilds have never ended up on Forbes magazine, ladies and gentlemen? That they really don't know what they're worth? Because everything's in trust. Everything. They own nothing, control it all. And none of it is reportable. Where would you start? It's all in trust. Who does it really belong to? I don't know. Right? So, due process. You got to give them notice. Why do we need a private account number notice in the public? Trower's Manual of Prevalence of Equity under the 25th section of the Judicature Act of 1873, amended by the Judicature Act of 1875, money and banknotes, H, may not be followed into the hands of a purchaser to whom they have passed in circulation unless he had notice of the trust. This is why in God we trust is on the money. They have a right to follow the titles into hands of the purchasers. A purchaser of a chosen in action, whether with or without notice, takes it subject to the equities in affecting its, and therefore to claim the Sestakay trust, but the protection of the protection of want of notice extends to the purchaser of bills of exchange, and the same rule would seem to apply, as the time within each Sestakay trust may sue him as in chosen in possession. Sestakay trust may follow the land in their hands without limits as to time, subject of the rules in equity, irrespective of statutes of limitation, bill for accounting to follow the interest in their hands without limits as to time. Public NOIs and SOIs on time only. Use this authenticated public generic record to prove your manifested intent to form a trust relationship, publicly reserving your private account number A, which will be an RR number. Let's just say it's registered mail number 123456789 US, and then we're going to add a hyphen 01 through 99. And the reason we're doing that is because we're going to do a lot of dictation, ladies and gentlemen. And if you're piss poor at dictation and keeping things organized, it is going to be a nightmare for you to keep a trust correct. Okay. And my dictation skills are not the best. But thankfully, we have great technology out there that helps us keep everything in order, everything in line, so we know what's going on. We scan everything in, we put it in a digital file. We can literally have it our office with us anywhere on a little floppy disk drive thingamajigger. And again, I'm not a computer tech, so floppy disk thingamajigger, that's what you get dealt with me. So I think they call them thumb drives. From here on out, floppy thingy. And sub-records for each record identified as RR 1, 2, 3, 4, 5, 6, 7, 8, 9 hyphen XX.001, right? Because we got 1 through 99, okay? And then we've got all the subs that come off of it. So, for example, if number 1 is going to be for my trust indenture, which is the law of the trust, it's going to be maybe number 1. I make number 1 the trust notice, and then from trust notice I go. It'll be number 1.01 for the trust indenture, and then further to expand upon that, let's say number 1, 2, 3, 4, 5, 6, 7, 8, 9, 2 is just for automobiles. Okay, that's a separate part of the trust that's going to be for automobiles, and then I got one that's going to be for houses, and then I got one that's going to be for medical bills, and then so on and so forth. Okay, you're just doing dictation, keeping your shit wired tight, your head on a swivel, making sure you're prepared for anything. You're giving everybody notices, and you just got your categories of what goes where. So number 5 might be banking. Number 1 obviously is the trust. Number 3 might be dental work or hospital bills or care and maintenance of your body, your vessel, whatever it may be. That's all you're doing. You're just keeping track of everything, okay? And you're turning everything into a trust because as the trust benefits the beneficiary, you can wear multiple hats, okay? You don't always have to be the beneficiary. You can come in as the executor if you wanted. You could also come in as the surety with the right of subrogation. It's just beautiful, beautiful, beautiful stuff. So, reading on. Through RR 1, 2, 3, 4, 5, 6, 7, 8, 9, 0.099, where XX is primary number, record 1 is notice of unregistered equitable claim. Okay, unregistered equitable claim. Remember, your unregistered claims are higher than the ones that are registered in the county anyway. Your private record, because you have firsthand knowledge of it, is superior to their public record. Poof. All right? No agent and agency, for the most part, can testify with firsthand knowledge that they have any knowledge of anything at all. Most often they get us because we are not learned and we acquiesce by tacit agreement or silent acquiescence. Our record trumps theirs. All right? Grantee, now coming as grantor of subject matter, hereby gives notice of unregistered purely equitable claims by nature, titles, RR 1, 2, 3, 4, 5, 6, 7, 8, 9 US, that's a registered mail number, hyphen 01 through 999, and their sub-records therefrom are fully claimed. And on special deposit, look at that, not general deposit, special deposit, in trust or otherwise. See exhibits and back. Restricted signatures. If a trustee signs a document with the intent to act in her capacity as trustee, but without including any designation of as trustee next to her signature, the trustee may unintentionally become personally involved in the transaction. For example, if the trustee intends to enter into a mortgage loan agreement on behalf of the trust, but she fails to designate her signature as a trustee's signature, then she may be held personally liable for the balance due on the mortgage loan. Sound familiar? at closing, sign here, please. Oh, sign here. And the banker's just whisking them papers away so damn quick, and you have no idea what you're doing. Sign here. Oh, yeah, don't worry about all that fine writing. We do this all the time. Just sign here, sign by that X. And did you see where I circled that initial there? Yep, perfect. Thanks. Have a good day. We'll get back to you. You don't realize you just signed a deal with the devil who's slick as slick gets. By agent. Ellipses mean incomplete information by surety, by trustee, without prejudice. Never, ever, ever, ever use the UCC codes. Why? Because yours is a private trust and equity. And the second you bring the USC, the UCC, any of that jargon into the exclusive jurisdiction equity, you could just walk your ass right back out of the Stargate, because you ain't going to be in there long. I promise. Because Henry Gibson tells you that those jurisdictions never, ever, ever under any circumstances mix. And Judge Tooley tells you that, and Judge Tawney tells you that as well. By giving name, restricted agent, without prejudice, without recourse, special private priority, in confidence. Another example, give name trustee. This limits your personal liability, such as on a mortgage. On private document, autograph, heir, K, private citizen of the United States. Private notice of property interest, private trust expression, the GGT, grantee, grantor, trustee. All right, that's your GGT. NOI, support, page 1128, conveyance and trust for payment of grantor's debts. Thus, where property is conveyed in trust for the payment of the grantor's debt, a trust results in favor of the grantor with respect to any surplus not necessary for the payment of such debt. The grantor, however, may of course part with his entire interest in the property assigned for such a purpose, and thereby prevent a trust resulting in his favor. Character in which trust results if the property transferred is personality. The trust result as personality. If the property conveyed is real estate, the trust results as real estate. Perfect title as grantee. Pay the excise tax of the 1863 $20 canceled stamp on template. Pay $10 to admit Article 1, Section 9 of the Constitution. See template. In support of NOI, Palmery, subsection 1265, a prior equitable lien created by a deposit of title deeds is superior to all subsequent claims of mere volunteers and of parties acquiring rights under the depositors with actual or constructive notice of the lien. Gibson subsection 55, priority of rights, show cause why I do not have superior equitable or legal title to property, and that it is not a trust, or be it resolved. You have 20 days to disclaim. Are you disclaiming the trust? Notice of interest, affidavit in support of the GGT. All right. Gibson, subsection 44. And when it is shown that such person have used money, real gold and silver coin, by them so held in trust or a stamp, in the purchase of any property, real or personal, taking the title in their own name, a court of chancery will impute to them an intention to fulfill their obligation, namely, to make the purchase for the benefit of the person entitled to the use of the consideration money, and they will be decreed to hold such property as trustee for the benefit of the parties whose funds were used in the purchase. Gibson, subsection 43, hence, it is the passing of the consideration and not the form of the contract that in equity passes title, and whatever the form of the transaction, if no consideration passes in equity, no title passes. Mortgages, okay, that just explained the cloud on title right there, all right? Mortgages, dear banker, or dear bank, show me the consideration you gave me for all the things that I gave you, and that it was equitable, all right? We're operating in good faith. We're doing things equitably. Don't you want your business partners doing things equitably as well? Yes, you do. You don't want them hiding behind statutes used as a cloak for fraud. No, 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 you don't. So Gibson, subsection 57, as men living by their labor and property, no man is presumed to part with either without receiving or expecting an equivalent in value. Hence, whenever one person has obtained either the labor or property of another, he should pay or account therefor, unless he can prove it was a gift. And so, whatever injury one person does to another's property or capacity to labor should be made good. Palmery, subsection 685, nature of the equities. The equitable interest created by a trust or by a contract in rem made upon a valuable consideration is superior to the equity arising from a mere voluntary transfer, a mere gift, or from a mere judgment lien in contemplation of equity. The interest created by a trust or by a valid executory contract of sale, or by a valid contract giving rise to a lien, or by an act in connection with such a contract constituting a lien. As, for example, a deposit of title deed is a real beneficial interest in the specific thing itself, and interest which is property or analogous to property. Primary or original relation being those that exist between the original parties to the transaction. 2. Secondary or derivative relations being those that exist between an original property and the privy of the other original party. And 3. Collateral relations being those that exist between the private of the original parties. Privies of the original parties. Certificate of special deposit, a natural title representing the legal estate. Delivery of a deed to trustee. Certificate of appointment. Certificate of trust. 2 witnesses, Gibson subsection 1164, or notary heading example. Now you can also use the 2 witnesses because it comes out of the Bible. It tells you 2 or more witnesses, okay? With first-hand knowledge, all right? The Declaration of Independence at Large, 4th of July, AD 1776. The United States of America at Large, 15th December, AD 1791. Here in the Iowa Stat at Large, 11 May, AD 1858. Oh, that's the, okay. Here in the Maple County at Large, 11 May, AD 1858. After you send notice of intent, now, or the NOI, notice of intent, now optionally send notice of tolling of time. Notice what date the trust vests. After you send tolling and enough time has passed to vest, now send notice of statement of interest, SOI, declaration statement of facts, of the establishment of the trust under the formation involving but not limited to your confession, acceptance, non-disclaimer, endorsement, delivery, transfer of legal title, parole on phone, agreement, express or implied, writ of mandamus, demand for performance and accounting signed by the beneficiary of the trust. Page 15, Tower's Manual of the Prevalence of Equity under the 25th section of the Judicature Act of 1873, amended by the Judicature Act of 1875, if the trustee with intent to defraud, convert, or appropriate the property to his own use, or dispose of or destroy it, he is liable to 3 years penal servitude or fine, or 2 years imprisonment with or without hard labor. Notice of breach of trust for failure of performance. Turn the page. Notice of pro confesso. Pro confesso must read Gibson, subsection 205 through 213. File petition for decree on the above facts. It's possible in your state the clerk will sign this once you serve the respondent and allow by rule 21 days to respond to clerk. When the clerk signs it, You now petition the chief judge in chambers to sign a decree and use the clerk's signed pro confesso judgment as your only evidence in support. When judges sign decrees, you are officially done. All persons worldwide must conform to the decree or suffer contempt of the judge's decree. The respondents must set aside decree to be relieved of it. That's also in Gibson's book. Enforcement. Objective, sealed, registered of Chancery of the Federal Circuit of the United States for the state of Iowa in care of the U.S. Court of Appeals or Supreme Court of the United States. Bill in equity, notice of law of the case under Maxim and Gibson, 64 sections, authenticated by state law librarian. See sample clerk letter. Captain parties, jurisdiction, cause of action, claim for relief, facts for affidavit, notice of evidentiary hearing, notice of private proprietary evidence in support for in-camera evidentiary hearing, best evidence, authentication of birth certificate, guaranteed bond or principal, debtor security that insures to creditor. Gibson subsection 785. The general rule of evidence that the best evidence obtained must be produced is as applicable to affidavits as to other evidence. Affidavits should, therefore, be made by those best acquainted with the fact to be proved, or a sufficient reason given for their not being so made. And all writings referred to in an affidavit should be exhibited, or a sufficient excuse given for not doing so. Okay? Something about the affidavits that needs to be mentioned in equity. Everything that is handwritten, ladies and gentlemen, carries way more force and effect than something that is typed up. If this documentation is handwritten, it's superior to their pleadings or any other documentation that is manufactured by a computer and a printer. Okay? Even a typewriter. Handwritten. All your joints must be handwritten. Joinder. Corpus juris secundum, pardon, and parole. A person who has such a title in a representative capacity as to be authorized to sue in his own name as a general rule may join the beneficial owner with him as plaintiff, and it is immaterial that the beneficiary may sue alone by reason of being the real party in interest. However, it has been said that it is only when the equitable interest would otherwise be unrepresented or perhaps inadequately or imperfectly imperfectly represented that the equitable beneficiary can be joined as a plaintiff. Let's revisit Federal Rule Civil Procedure 17A.3, joinder of the real party in interest. The court may not dismiss an action for failure to prosecute in the name of the real party in interest until, after an objection, a reasonable time has been allowed for the real party in interest to ratify, join, or be substituted into the action. After ratification, joinder, or substitution, the action proceeds as if it had been originally commenced by the real party in interest. Principal is represented by administrators. Also note that error is not in the Federal Rules of Civil Procedure, Rule 17A. Only God creates errors, ladies and gentlemen. That rule is saying that you have the option of either beginning any case as a joinder with the plaintiff or being the case as the defendant. It's your choice. Do you see what is being waived here in equity? They give you a chance to join the plaintiff and you don't. After a reasonable amount of time, they proceed as if the real party joined. But why? Because you consented. And once you consent, you are deemed to have waived your right to be a joinder. So, you are volunteering to be the defendant after being given the opportunity to be the joinder with plaintiff. After objection, which is another way of saying, unless you object, you waive it. Okay, so if you don't know your rights, you don't have them, and unless you object, you waive it. And in equity, you are now a volunteer. And remember, equity doesn't aid volunteers. You just told the court that you would rather freely be the defendant than be the piggyback ride on the plaintiff. Declaratory relief. Declaratory relief is appropriate when a litigant needs direction from a court before taking further action or future action. Such direction will afford the litigants relief from uncertainty or insecurity. See Armor Household Products, Inc. versus Evans Manufacturing, Inc., 139 F. Supra, Superior Court, 2D, 1235 through 1235 and 1239, ND All, 2001. The object of the declaratory judgment is to permit determination of a controversy before obligations and repudiated or rights are violated. As many times pointed out by this court, its purpose is to permit one who is walking in the dark to ascertain where he is and where he is going, to turn on the light before he steps rather than after he has stepped in a hole. Cox versus Athens, Reg Med Center, 279 Georgia, Appellate Court, 586, 594, 631, SE2D, 792, 799 in 2006. Exclude public and press. Maxim. The inclusion of one thing is the exclusion of another, and vice versa. The exclusion of one is the inclusion of another. Petition to exclude the public. All right? You're not a federal district citizen, or maybe you are. I don't know. Maybe you are a U.S. citizen. That choice falls on you. I'm telling you right now, if you're still of that mindset and you're watching this, I'm hoping I'm planting seeds for you. Petition the court to show cause why my private citizen rights should be commingled with that and those rights of the public enemy, belligerent, and rebels, or be it resolved, this cause shall proceed sealed and ex parte. Yeah, it's going to be a parte. Or be it resolved, this proceeding shall commence by order of the court, sealed and all third parties barred from its access. What do we mean by third parties? Lawyers, the lying craft, the devils, keeping them out. We're kicking them out. They can't be in the exclusive jurisdiction equity. Now, there's going to be a lot of lawyers out there that watch this and are like, this kid is full of shit. You're entitled to your belief. Far be it from me to teach you the law. If you don't understand what I'm teaching you, if you don't understand what I'm showing you, then I suggest you go hire a competent attorney to explain it to you. But I'm not here giving legal advice. Okay, that's for lawyers. They do that shit. So for you lawyers out there that are seeing this going, man, this guy's nuts. Again, seek legal advice from an attorney. I don't give advice. All right. Attached proposed orders, all right? Federal Equity Practices, American Technical Society, Library of American Law and Practice, Equity Procedures, 1919, book page 64, section 81, Dual Systems of Jurisdiction. The federal courts keep entirely separate actions at law and suits in equity, and for damn good reason. As much so as did the Court of Common Pleas and the High Court of Chancery in England 100 years ago. This is affected by the device of having two sides to the court, all right? The law side and the equity side. And between them, there is no possible connection. If he wants or needs equitable relief, he must depart from the court on its law side and enter the equity door on the other side, where he will be heard by the same judge acting as chancellor. Ladies and gentlemen,
you may be in equity. You may not even realize that you have done it. I know the first time that I experienced some equitable relief, I didn't recognize it until months later when I was like, oh my gosh, look what he did for me. Wow. So, don't go in there expecting to see a magic trick. Oh, now you see it, now you don't. Sometimes you don't see it. Sometimes it takes you a while to figure out what they've done, how they did it, and why. All right. But stay vigilant. Remember, because equity doesn't aid a volunteer. Equity aids the vigilant. Newby versus Enron. 2002, the court held that the federal courts have the equity jurisdiction that was exercised by the English Court of Chancery at the time of the adoption of the Constitution. Get to go back all the way to 1776, baby. All right, 1791, however you want to look at it. Constitution and the enactment of the original Judiciary Act of 1789. The court further noted that regardless of the merger of the formerly separate courts of law and equity by the federal rules of civil procedure and substantive principles of courts of chancery remain unaffected. All right? That's beauty. That's magic, people. That's the founding fathers. That's good people within the system making sure that the people will always have a backdoor remedy. Always. Always, always, always. It's so important. Okay? Some of the earliest writings of the equity jurisdiction of English courts emphasize the exclusive role of the equity courts over suits arising out of a breach of the fiduciary duty. It's a trust. Everything's a trust. 63 Charlie Am Jurisprudence 2D. All public officials are trustees of the American people. All right? You just got to find your way back home. We're off the reservation. We a long ways away from home, running around going, we're U.S. citizens. Yes, sir, we a U.S. citizen. Answering to sir and ma'am, and there's just so much behind that. But once you make your claim, once you come forward and make your declaration, all that changes. You just got to stand firm on your paperwork. That's why nobody can do this for you. You have to do it for yourself. Because if I was to create your paperwork for you and you didn't know what it was, and they start asking you questions, you're in trouble. You're in trouble. You just falsified a record, tried to come into the heavenly place of equity to get equitable relief, and you've been dishonorable. You're gonna get spanked. They might bring sanctions against you for falsifying a record, trying to get into heaven without knowing what you're doing. All right. C.L. Bates, Federal Equity Procedure, Volume 1 and 2, 1901, subsection 11, the jurisdiction must appear upon the face of the record. The jurisdiction of the circuit court is limited in the sense that it has no jurisdiction other than that conferred upon it by the Constitution and the laws of the United States. And, as a result of the limitations upon the jurisdiction, the presumption is that a cause is without its jurisdiction unless the contrary affirmatively appears. It has long been settled that the facts upon which the jurisdiction of the circuit courts rests must, in some form, appear on the face of the record in all suits prosecuted before them, and it is error for the court to proceed until its jurisdiction is shown. Chief Justice Taney, discussing the necessity of the record showing the jurisdiction and the reason of the rule, said, but in making this objection, we think the peculiar and limited jurisdiction of the courts of the United States has not been adverted to. This peculiar and limited jurisdiction has made it necessary in these courts to adopt different rules and principles of pleadings. So far as jurisdiction is concerned, from those which regulate courts of common law in England, exclusive equity, and in the different states of the Union. Okay, so different Union states, different from the United States, which is just the District of Columbia. Now we have the Union states we're talking about, which have adopted the common law rules. In these last mentioned courts, where their character and rank are analogous to that of the Circuit Court of the United States. In other words, where they are what the law terms courts of general jurisdiction, they are presumed to have jurisdiction unless the contrary appears. All right, so you got to plead the conflict of variance between the rules of equity and the rules of law. You got to show them ain't got no jurisdiction, no impersonum, no subject matter. You got to spank them right out the gate. Because remember, if you waive it, you lost it. All right, if you don't raise it, you waive it. No averment in the pleading of the plaintiff is necessary in order to give jurisdiction. If the defendant objects to it, he must plead it specifically, and unless, because remember, equity acts specifically, so he must plead it specifically, and unless the fact on which he relies is found to be true by a jury or admitted to be true by the plaintiff, the jurisdiction cannot be disputed in an appellate court. Now, it is not necessary to inquire whether in court or courts of that description a party who pleads over in bar, when a plea to the jurisdiction has been ruled against him, does or does not waive his plea, okay? Nor whether upon a judgment in his favor on the pleas in bar and a writ of error brought by the plaintiff, the question upon the plea in abatement would be open for revision in the appellate court. Cases that may have been declined in such courts, or rules that may have been laid down by common law pleaders, okay, can have no influence in the decision in this court. We'll talk about equity. Because under the Constitution and laws of the United States, the rules which govern the pleading in its courts in question of jurisdiction stand on different principles and are regulated by different laws. Article 3, subsection 2, subpart 1. All right, that's where you got to get. I'm drawing you a map. This guy's drawing you a map. Bless his heart for all his hard work and his energy that he has put into this to simplify it for us all. And he's got some new stuff out there that's fantastic. This difference arises, as we have said, for the peculiar character of the government of the United States. For although it is sovereign and supreme in its appropriate sphere of action, yet it does not possess all the powers which usually belong to the sovereignty of a nation. Certain specified powers enumerated in the Constitution have been conferred upon it, and neither the legislature, executive, nor judicial department of the government can lawfully exercise any authority beyond the limits marked out by the Constitution. And in regulating the judicial department, the case in which the court of the United States shall have jurisdiction are particularly and specifically enumerated and defined, and they are not authorized to take cognizance of any case which does not come within the description therein specified. Hence, when a plaintiff sues in a court of the United States, it is necessary that he should show in his pleadings that the suit he brings is within the jurisdiction of the court and that he is entitled to sue there. Okay, i.e., private American is a national citizenship. Okay, part of the Union States. You're not part of Washington, D.C. You're not part of the United States. You're part of the Union States. You could go as far to say that you're an Arizona national or a Nebraska national, part of the Union States. That is directly tied to the Constitution for those Union States. All right? And if he omits to do this and should by any oversight of the circuit court obtain a judgment in his favor, the judgment would be reversed in the appellate court for want of jurisdiction in the lower court below, and that'd be the inferior court. The jurisdiction would not be presumed, as in the case of the common law English or state court, unless the contrary appeared. But the record, when it comes before the appellate court, must show affirmatively that the inferior court had authority under the Constitution to hear and determine the case, First Scott versus Stanford Supra. This peculiar and limited jurisdiction has made it necessary in these courts to adopt different rules and principles of pleadings, so far as jurisdiction is concerned, from those which regulate court of common law in England and in the different states of the Union which have adopted the common law rules. Exclusive equity. Union is the de jure reference, or de jure, however you want to pronounce it. The power of the judge in chambers under equitable rules of chancery, equitable remedies, Palmery, subsection 355, it was decided that the individual judge acting in chambers have all the powers and functions which were possessed and exercised by the chancellors in chambers. Gibson, subsection 770, in general, the chancellor's jurisdiction at chambers now extends from the hearing of the simplest motion, such as to amend pleadings, to the supremest act of adjudication, such as the rendition of final decrees and their enforcement by all necessary final process, as will be hereinafter more fully shown. Palmery, subsection 296, illustrations. The foregoing principles may be justly regarded, I think, as the very foundation of the equitable jurisdiction of the United States courts. They give it whatever peculiar character it possesses, growing out of the double organization of the national and state governments, and they clearly distinguish it from the jurisdiction possessed by any state tribunals. In the particular administration of their equitable powers, the national judiciary have constantly affirmed and steadily adhered to the doctrine in its negative form. Okay? Always looking at it in its negative form. That the equitable jurisdiction does not exist. Okay, but let me ask you something. If the equitable jurisdiction doesn't exist, why the heck are they mimicking it on the outlaw side? Because it does exist. Injunctions, the MERS, all that stuff is equitable. Okay? Or will not be exercised in any case or under any circumstances where there is an adequate, complete, and certain remedy at law, sufficient to meet all the demands of justice. All courts run on waiver and consent. If you do not change the rules, then you agree with the rules. For example, in Minnesota 48.4.33, rule of practice, the judge of the district court may revise and amend such rules as they deem expedient, conformably to law, and the same shall take effect from and after the publication thereof. Such rules as the same shall be so revised and amended from time to time, shall govern all the district courts of the state, but in furtherance of justice, they may be relaxed or modified in any case. So, what's it saying? Well, basically what it's saying is there are times when statutes apply, and then again, there are times when statutes don't. And I've actually had a judge say that to me. You know, Derek, there are times when statutes apply, and then again, there are times when they don't. And that particular court case was dealing with an officer pulling me over for having no plates on a private household consumer good. Okay? I didn't know what I know now back then, but I knew enough. And what was interesting about it is when I brought up the argument that he flipped a U-turn, he had to be going twice my speed to catch me within the proximity of the mileage I had driven since he had seen me. He was breaking the law. He was speeding. Not to mention declaring an emergency, pulling me over absent a victim. There's no crime. There's no injured party. There's no damaged property. And he goes, Derek, yeah, there's this thing that you should probably know. There's times when the statutes apply, and then there's times when they don't. All right, do you understand? And I'm like, no. Well, that's okay. You don't have to understand. We're moving on. I was, ooh, son of a gun. So this is where we're at here. Or a party relieved from the effect thereof on such terms as may be just. This is the equity or changing of the rules in your case. Any other proper business pertaining to the judiciary may also be transacted. We use the 1912 Federal Equity Practices Rules. We have found that following Gibson's book, 1907, is near perfect in today's practice. The few exceptions are cured by Story mostly and Pomeroy and Gibson's 8th edition. Package to... Yeah. Sorry, guys. I can't go any further. My eyes are killing me. Anyway, thanks for joining me. Hope this helps you guys out. Just trying to plant some seeds. Just trying to help you guys ascend to the mind. That's all. So we'll see you soon. Thanks for all your support. Thanks for all your donations. Join us at selfgovernanceU.com. And thanks again. Appreciate it. You guys have a wonderful, blessed morning. And be careful out there.